to Thursday afternoon webinar time. I'm Chris Irons, for those of you who have forgot, who don't know, who don't care, and I am Director of independent Strata consultancy firm Strata Solve. With me, as always, again, for those of you who don't know or don't remember, Frank Higginson, partner Hines Legal. Not that anyone would ever do that. Frank, welcome.
No, hello, everyone. Hello, Chris. I suppose here we go, almost at the end of January and into it again. With nothing to talk about at all.
Nothing. No. As always, we will try and respond to comments made live today. But if your inquiry is a bit more complicated, try and use the link that has popped up in the comments space. Today, Frank, we got derailed, didn't we?
We did get derailed, so let everyone on a little early hint. Next week's webinar about what's coming up in Strata for this year from our perspective. No, we got derailed by a little Christmas present that became public earlier this week, which really is a completely new interpretation, in a sense, on smoking in Strata using existing legislation. So I think probably one of the lines we've been bouncing around using, probably me in particular, over the last couple of years, is no such thing as a pet-free building in Queensland. And you could argue, in one sense, based on this decision, that there's no such thing as a smoke-friendly building in Queensland, based on what we're about to talk about today.
I think that's a fair assessment, Frank, and everyone can argue whether or not it has that kind of impact or not. Today we're going to try and unpack what this new decision tells us, and it is very new, only made literally the last working week of 2021, and only now coming to light because it hasn't even been published yet. But us being Strata experts got our hands on it, so there you go.
We will put up a link to it in our comments so everyone can have a read if their own, make up their own mind after we've finished, I suppose, discussing something that is brand new, isn't it?
Absolutely. So without further ado, let's rip right into it, Frank, and maybe a few some really basic things to begin with. So this is a decision of the adjudicator in my former office, the Office of the Commissioner for Body Corporate and Community Management. It's not a QCAT decision, it's not a court decision, it's a decision of the adjudicator, which is still a legally binding decision and legally appealable. That's important to note. Building on the Gold Coast, it's been blabbed in every news outlet in the state, so no harm in us saying it was the Artique building. And Frank, it was a dispute not between an owner and the body corporate, but owner and owner, wasn't it?
Yeah, which is a really interesting one. So, and as always, probably the thing that always interests me in these things is the time. So this actually officially started in November 2021? No, November 2020. So that's when conciliation happened and the adjudication decision was handed down on 21 December 2021. So it's been 11, 12-month gestation process inevitably, plus whatever happened before that. And I suppose normally the difference is, and I suppose it's one of those things, we covered this in bylaw enforcement. I'm pointing like that's last year. We did cover in bylaw enforcement last year that owners can take on bylaw enforcement proceedings in their own right without relying on the committee to do it. And this is one of those things that's actually happened. It's a pretty rare thing to see it run the distance. So it's effectively a dispute between two owners, which the Commissioner's Office has primary jurisdiction with respect to. And I suppose, in essence, and when people read the decision, they can have a look at it. One owner complaining about another owner allegedly chain smoking. The person who was complained about says, no, a packet of smokes lasts me a week.
So that was one floor above the other, wasn't it, Frank?
Yep, absolutely. Just directly up and down. And that was the dispute.
Yep, that was the dispute. I think the important points to sort of note there is that the length of time, we've been banging on and on about the length of time it takes to get outcomes from my former office. Well, this proves it. That's probably even more than we have been saying. So that's one point. The other point is even that is probably a conservative estimate about how long there's been acrimony there. It probably has been going on for some time beforehand. So anyway, just to finish off that discussion quickly, the applicant went to conciliation, no dice at conciliation, decided to keep going to adjudication. Not always does that happen, as Frank pointed out. And then an order resulted. In all of these cases, of course, the respondent, the smoker, it was asked for their views. You can't really have a case without seeking the views of the other party. And the respondent said many choice things, but most interestingly of all said, disputed that they were a chain smoker and said bylaws don't apply to me, which is an interesting concept of itself.
Well, it's a bit of a red rag to an adjudication bull in a sense, isn't it?
Well, it's a red rag to everybody, I would have thought. Yeah. So that's the scenario that we're facing. So it's not an owner sort of trying to resolve this internally. It's going right through the entire process of the Commissioner's office. Frank, the decision then, what's the big deal?
Well, I suppose if you go back to, and I mean, we've done webinars on smoking probably very much at the start of COVID, so 2 years ago, there or thereabouts. And so where it all starts is really section 167 of the Act says that people can't use their lot or common property in a way that causes a nuisance or a hazard. So every smoking dispute before now has been predicated on smoking being a nuisance. And so the lead case in QCAT on that, which is Norbury versus Hogan, effectively said that unless someone's out there smoking 24/7, and you can prove that, and potentially there's evidentiary issues around, like one of the adjudications spoke about getting a machine that can measure the toxicity or level of the smoke and all that sort of stuff, which is obviously hard to do. So up until now, all of the smoking arguments, and there's plenty of them, have related to whether someone's smoking is a nuisance. But where the adjudicator has gone in this particular matter has gone to the second part of that section 167 and referenced hazard. So, and really interestingly, I mean, you can't really say the adjudicator's gone off the reservation because she hasn't, because this is in the legislation, but it's not ever been something that anyone has focused on. And as best I can tell, in this matter, it seems both parties were self-represented. So it's sort of a bit of a complaint from one owner defended by another owner, which I suppose is what the Commissioner's Office jurisdiction is designed to allow in the context of people running their own individual disputes in there. And just one little paragraph that I took out of the adjudication that I thought was really interesting, where the adjudicator said, to her knowledge, the issue of whether smoking constitutes a hazard, contrary to the Act, hasn't been specifically canvassed in Queensland. And the applicant in the matters does not appear to have explicitly asserted that the smoking in dispute constituted a hazard, whether it was also a nuisance or an unreasonable interference. So in this particular dispute, the adjudicator has gone on to effectively say, you know what, smoking, this smoking isn't a nuisance and it's not an unreasonable interference, but it is a hazard.
And interestingly, Frank, the adjudicator then just went on to pick up literature publications by state and federal governments to, and didn't really go into that in a huge amount of detail, but nonetheless pointed to that as the evidence for suggesting that secondhand smoke is a hazard. To the point where the adjudicator, not in these words, but effectively said, well, I accept that it's a hazard. It's been shown to be one. That is very, very different to having to prove a nuisance, as you just said, Frank, because proving a nuisance when it comes to smoking has been just about impossible, hasn't it?
It's been really difficult. So I think the adjudicator here is again, going to those publications and, you know, I suppose it is pretty hard to argue that secondhand smoke is not necessarily a hazard, because it is. I think that's been factually proven. Mm-hmm. And even, I suppose, and this is where it gets really interesting from, well, for future disputes, because there's going to be plenty of those, and we'll talk about where we think those might come from soon. Because there's been no real judicial interpretation of hazard in the context of the BCCM Act, the adjudicator's gone to the Macquarie Dictionary, which is where you go, and that this is referenced in the decision itself as well, and said that hazard is something that's a risk, it's an exposure to danger or harm, or the cause of such a risk, or a potential source of harm, injury, or difficulty. So I suppose we've got secondhand smoke, lung cancer at its worst, probably other things affecting, you know, maybe causing emphysema or otherwise. So adjudicator has gone secondhand smoke, hazard, bang, that is something that the Act, and in this particular building, the bylaws, prevent from occurring. And as a result of that, there's going to be consequences. So it hasn't been dismissed on the basis that it's not a nuisance, because that's where every other smoking dispute thus far has gone. It's been accepted as being a hazard without really, I think, the applicants making much of that in terms of evidence, because the adjudicator's gone to searchable, publicly available information published by governments and said, well, that's it. It's obvious.
It's part of the adjudicator's fairly wide-ranging role in this sort of thing. An adjudicator has quite broad powers in these kinds, in all disputes. And this is one aspect of it. As for what happened after that, the adjudicator has ordered that alleged, or not even alleged anymore, chain smoker has ordered that chain smoker not smoke on their balcony. And of course, in a building of that type, the balcony is part of a lot. So somebody has been ordered not to smoke in a part of their lot. Not only that, Frank, the adjudicator went on to say that if the owner chooses to smoke indoors, they have to take reasonable steps to ensure smoke does not get out. So we now have a situation where an owner has been, first of all, forced inside, told they cannot use their lot in a particular way, almost to the point where they basically can't smoke in the lot at all, arguably.
Well, I think, and the adjudicator went there with shutting doors and windows and all the rest of it. But it's a really interesting one in terms of that interference, in a sense, with people's property rights. So if you go, you love the castle, it's all about the vibe, Your Honour, in front of the High Court. In theory, once you go inside that front door, normally it's your domain to do with as you see fit, provided you don't interfere unreasonably with other people's use and enjoyment of their lot. But now we've got that little rider, or act in a way that causes a hazard. So hazard is probably going to be the word of the year from a Strata perspective, or at least.
Frank, are you there? Hopefully people, if anybody out there is watching, if you just message to let me know if you can hear me or Frank. I do appear to have lost Frank on the feed. Anybody? I'm going to continue as though Frank has been lost from the feed then in that case. Yeah, I've just had, thank you, bodycorporate.com.au. Thank you, everybody. I'm going to continue. Sorry. Oh, no, you're back. Woohoo!
No, just that magical, the screen drops out. Nothing else died. I do not know why. So,
well, let's keep going then, Frank.
I'm glad everyone's missing me, though.
Yeah, thanks, everyone. God, you people are awesome. Let's talk about hazard then. So we've covered what happened. We've covered the decision. And remember, the important thing in these decisions are enforceable through the magistrate's court. So that is the next step in this process if the other party doesn't comply. So hazard then. Why is this such a big deal? Well, it's a big deal, first of all, because the need to have to prove nuisance is effectively gone when it comes to smoking. Why else is it a hazard, though, Frank?
Yeah, it's interesting.
Sorry, why else is it a big deal?
Yeah, well, and so this nuisance test, and one of the reasons, come back to Norbury versus Hogan, all that sort of stuff, nuisance requires a substantial degree of interference according to what reasonable standards would otherwise be. So it's not it's an objective test. So it's not just how you feel about it, it's how ordinary people would feel about it. So, substantial degree of interference. So you've got all these words that mean something that's much bigger. Hazard is now something that is a risk or can cause a risk or exposure to harm. So for me, and it's been interesting, ladies and gentlemen, I know a few of you are watching by virtue of the fact that you've popped up with where is everyone, is as I've been driving around this morning and chatting to Chris about, well, we've got to do this, we might as well. What else is a hazard? So, and this, I think, is what's going to be the real big issue for Strata. So we've now got absolute view from adjudicators that smoking is a hazard. What about carcinogens from steak cooked on a barbecue? Does cooking meat produce something that could be a hazard?
Let's talk about incense for a moment, Frank. The incense of itself, you'd be hard-pressed to suggest is a hazard. But the smoke from incense, for a person who is sensitive to that sort of thing, that's a hazard now, isn't it?
It is. And we don't seem to have, we haven't yet got the dictionary definition of, substantial degree of hazardness.
Mm-hmm.
For someone, it's that might be a little bit of a subjective test, which means that it relates to how you feel about it, not how the ordinary person might feel about it. What about COVID? What about someone in a building who's got COVID and leaves their unit? Is that causing a hazard? Catching COVID is probably a hazard. Exposing other people to the risk of catching COVID by touching something and not cleaning up after yourself is a hazard.
And there'd be no problem, you would think, demonstrating that COVID is a hazard from other sources. I suppose the issue there, though, Frank, is that by the time this matter gets to this point, the person would presumably no longer have COVID. But what about the declaration that they have caused a hazard? That of itself.
No, and another one, like we did this sort of, we do an 8:30 whole of office meeting every morning. So this morning we ran through this with everyone, asked everyone to throw ideas at me in terms of what might be a hazard. And this is what happened at La Crosse in Victoria. That fire in that building started from someone smoking on a balcony, putting the cigarette butt in the little ice cream container that had the rest of them. Fire started up and down the building because of the polyethylene in the cladding. Smoking in the sense of an exposed flame as a hazard. Particularly, I suppose, if your building's got composite cladding that doesn't comply with what's needed now.
Other stuff, Frank. Loud music that
preventing sleep,
or loud music at such a decibel that causes hearing damage.
Yeah.
What about glass in the pool?
That could be hazardous. You break a glass and people step on things. Obstructing fire exits. Storing stuff in fire wells. These are all hazardous things, aren't they? Or hazardous. They expose people to risk.
And I suppose everyone out there watching this is going, "Oh, come on." But the point of this is literally a new frontier in body corporate disputes. There has not been a dispute of this type in relation to hazard. So now, because those doors are open, we're now thinking about all of these other things. The other point to note here that in the adjudicator's order, the adjudicator referred not to cigarette smoke. The adjudicator referred to tobacco products. Tobacco product is more than likely, if not certainly, vaping. So there's something
marijuana,
else to consider.
Marijuana?
Frank, you have gone away again.
Have I?
You've gone silent, Frank.
Oh.
While Frank gets finds out how to get volume back, I'm going to continue, everybody. Sorry about that. It's the first webinar of the year, technical problems and all of that jazz.
Is that good?
Vaping. We think vaping is covered by this. And again, everybody, if you could just comment. Frank is coming back. I want to get Rebecca. Thank you for your question, Rebecca. We are going to get to that question because I think that poses a really interesting point that you have raised. So bear with us and we will get to that one. Apparently everybody can hear Frank. I can't hear Frank. That's a bit problematic. Frank, given that I can't hear you at this point, do you want to talk about ramifications?
Yeah, but it can't see me. This is very, I suppose the other thing that is hazardous is technology doing things like this because the blood pressure tends to rise a little bit. So here we are. So ramifications, I think, then is really some of the other things that is bouncing around. So for me, the issue in this particular building is people under another.
It appears as though, from what everybody's saying, that Frank has gone. So I'm going to continue on. So ramifications. Well, the biggest one now is that people who had previously been dissuaded from applying for dispute resolution with the Commissioner's office. Apparently we are now both live. Does that sound right, everyone?
Hello. Yay, crikey.
Yes, you're back, Frank.
Yeah.
I still can't hear you. Frank, over to you to talk about ramifications.
Yeah, because the other thing we were bouncing around, so we've got, new definition or new issue that's a hazard. We've then got this smoking issue was one person below another. So even talking to my wife about it this morning to say, here it is what happens if you're in the penthouse? If you're in the penthouse and smoke only goes up, is that hazardous to someone below you? That's a question, possibly not. And the other one, of course, is this building, Artique, is a high rise. So again, people vertically living on top of each other. What happens if you're in a standard format or group title format, so a townhouse estate? So you're side by side. At what stage and at what distance does smoke potentially not become hazardous? So if it's going up and then you get the smell across. So there's all of these little things, nuances that'll come out probably over adjudications over the next 12 to 18 months, subject to whether the government actually does anything about this in the meantime, because this has come from left field, because this has been an issue. So Chris, you can't hear me? No. So this has been an issue that has been lurking around from a legislative perspective for probably 6 or 7 years in terms of what's going on. And it's certainly something that's going to be discussed and has been discussed at the Strata Title Law Reform Working Group in terms of whether buildings can or should be able to regulate smoking. In effect, an adjudicator has done that cold by virtue of this decision in terms of making smoking or declaring smoking as a hazardous issue. So what can change from here? Inevitably legislative reform. You take the word hazard out, we're back to the old regime. You define that a bit differently. Maybe that changes what's going on with smoking. Definitely an appeal. So this is a decision that sits there now in the Commissioner's office, and it'll be the benchmark that we're all with until it's appealed or there's a decision of a higher authority, which in this case is going to be QCAT. And that's really it. So it's really interesting in terms of the left fieldness of it. So probably what we can see coming is bucket loads of smoking disputes. Like there's no way that this isn't going to prompt a whole lot of those, because even when we did our first smoking webinar 2 years ago, there's still the odd comment that pops up on our Facebook feed. Chris, can you hear me? No, still playing silly buggers. So it's a very emotive topic. So it's really, in terms of issues that pop up in Strata, pets, parties, smoking, towing cars. So this is one of the biggest issues that is a constant source of disputes in the dispute in the Commissioner's office, despite the fact that the law on it, up until this decision, was relatively settled. So we're going to have...
I can hear you now, Frank, by the way.
Right. Look at this. So we're sharing the technical issues. So I was just talking about the ramifications in terms of the BCCM office is probably going to get a hell of a lot busier with arguments about these sort of things and start to deal with penthouses, adjoining properties as opposed to vertical properties, distances between neighbours. And I suppose even if you look at the facts of this particular case, the allegations of chain smoking versus one packet a week, maybe some more substantial or substantiated evidence around how much smoke actually is a hazard. Because in theory, I mean, we're all exposed to this when we walk around the streets every other day. So at what level, and this is a relevant question, I suppose, that hasn't quite been addressed in the adjudication, at what level doesn't it become hazardous enough, or does it become less of a hazard to the extent that people can be exposed to it safely? Or is there no safe level of exposure to secondhand smoke? Like these are the things that'll be ventilated over the next couple of years. So there's 6 weeks for an appeal. So the body corporate can appeal it, but it need a special resolution to do it. So that's probably out of the system. The reality is that it's probably one of the only person who really might appeal is the affected lot owner who was ordered to smoke inside.
Because nobody else made a submission, Frank.
No,
I don't think. Yeah, and so this is
there's only a couple of little things. Yeah.
Yeah, this is the good learning that comes out of this experience. If ever you're invited to provide a submission to an adjudication application, you can choose yay or nay. But if you choose yay, that makes you somebody who can potentially appeal the issue later on because you have contributed to it. Frank, really quickly, let's talk about the other issue that came out of the order.
Well, 2 little paragraphs at the back end where the committee got a little bit of a slapping, didn't it?
A little bit. So adjudicators are human, everybody. You might not believe it, but they are. And if they think that something has gone on that should not have gone on, they are unafraid to give people a whack. And that's what's happened here.
Yeah. So really, at a macro level, committee's got a statutory obligation to enforce bylaws. Owner complained to the committee about bylaw enforcement, or about the bylaw being breached, because they had a fairly effective bylaw, to be perfectly honest, in relation to nuisance, hazard, smoking, smoke drift, the whole box and dice. And the committee said, you know what, that's a dispute between you guys. You go and figure it out.
Washed their hands of it, didn't they, Frank?
Yep, absolutely. And what the adjudicator said in relation to that is that the body corporate didn't necessarily need to issue a bylaw contravention notice, but it should have done more to actually investigate their ability to do so, and then actually make a reasonable decision on whatever basis. So, the committee might get legal advice on that, and it would have been interesting to see whether everyone would have jumped to the hazard element of it, because interestingly enough, even the applicant didn't allege hazard. Probably, the blink is on. You might have only spoke about nuisance, but in this one, the committee didn't do any of that. They said, no, your problem, dispute between 2 owners, you go figure it out. And the adjudicator said, that's actually not the right way to do it. The committee had an obligation to actually understand the issue and investigate the issue, and then make a reasonable decision about whether or not they should be involved.
I actually think, Frank, that that's as big an issue as the actual hazard issue in this particular order. The realization that committee can't just say, no, sorry, you figure that out yourself, it's got nothing to do with us. There might be some instances where that's true and appropriate and reasonable, but I think what the adjudicator is saying here, that for the main, if you're in a community, particularly in a high density, high rise one like this, and you've got 2 parties in conflict, and in fairly open conflict at that, for a problem that has the potential to affect others, you can't just say we've got nothing to do with it. I think that committees are now on notice about that and about their responsibilities, Frank, and we might cover that issue in a standalone webinar coming up, I reckon.
Because there's probably, there will be committees out there with complaints about smoking, but in higher density buildings, there's probably not a committee out there that hasn't copped a complaint about smoking in some way, shape or form. And up till now, you may well have said, well, we don't have evidence, it's not a nuisance, refer you to this decision, you go and get us some more information. But it's this one, the committee, it seems, washed their hands of it completely. Didn't even go back with any questions. So yeah, the adjudicator, a little bit of a smack.
We will come back to that in a bit more detail another time. Before we do our quick takeaways out of today, I just want to go back to your question, Rebecca. Thanks, because you've given us some good food for thought there. How do you think accommodation module buildings will go, especially ones that only allow smoking on balconies? Really good question, Rebecca. So I think the first thing that we do is we turn to that section, and I'm interested in your views on this, Frank, obviously, but we turn to that section 167. The occupier of a lot included in a scheme must not use or permit the use of the lot or common property in a way that causes a nuisance. So obviously the short-term person, the holiday maker staying there, is the one smoking at that point in time. and causing smoke drift. But does it then extend to say, well, the person who's letting that lot out, be it through the on-site manager or through Airbnb or through a real estate agent or through some other platform, is that person the occupier who is permitting that lot to cause a hazard?
That's a good question, mate, because the owner absolutely has the ability to say to their letting agent, do not let people smoke in my unit. And so if they don't do that, are they authorising a hazard? Good question.
I would say yes, they are. So, Rebecca, in answer to your question, I think they're definitely covered, and there's big implications for holidaymakers who, after a hard day at the beach, want to light up. I think that's problematic. And you've given us another question very quickly, Rebecca. Could you install a water screen or a mister to contain and filter the smoke? That might actually be a reasonable step on the part of the smoker or the owner of the lot, subject to how effective and how well it works. Frank?
Absolutely. And I suppose the objective evidence on that, because one of these things, it's really interesting, this one, there didn't appear to be a whole lot of evidence go in, as opposed to the usual assertions about they're smoking too much. No, I'm not smoking anywhere near what she says I am. Evidence around something like a mister would have to be objective. It wouldn't be a personal opinion, but that's absolutely something that could be done. And I suppose, looking at Bryce's question there, I think probably from a legal perspective, this is one of those ones that on appeal, there's arguments to be made both ways. So if it is appealed, it'll be a really interesting thing to see that the legal arguments put out properly, because it's sort of degrees of hazardness.
Yeah. We need to wrap it up, everybody. Very, very quickly, our takeaways. We've said quite a few of them already, haven't we, Frank? But for everybody to think about, what does this mean? Well, we think a new era for smoking disputes. Is it the start of a wave of new adjudications or a new way of doing adjudications? Does this start applying to other hot button issues? One wonders. The other takeaway, and I'm just going to say it, I think it's time for government to step in now and offer the clarity on this issue. The decision's been made for them to a point. Time for them to step in and do something with it. And the other big one, committees and managers are going to have to start to get proactive and take responsibility. I'm sorry, but that's just how it is, everybody. I'm sure you've already got plenty of other things to do. Here's something else that you need to think about.
The genie is well and truly out of the bottle on this one.
It is now. So no doubt we'll come back to this one at some stage, I reckon, Frank. And also, as I said, that issue about committee responsibility. Next week, we're going to try and go back to the one that we were doing, which was what we expect this year, unless, of course, something else happens this week, which is not beyond the realms of possibility. Frank, it's been a challenging one for all sorts of reasons. It's been good,
we started together, we finished together with some short absences in between, which is fine.
It's good. Most importantly, I reckon, Frank, thank you everybody for getting back into the swing of it. There's a lot going on in the world at the moment. So thank you for taking the time to be here. It's appreciated.
And we're trying to avoid talking about COVID, but you couldn't duck it on this one.
And we probably won't avoid it next week either.
No.
Yeah. All right. Thanks, everybody.
Thanks, everyone. See ya.
Bye-bye.